Hi, my name is Stacey Schwartz, and I am an attorney at the Flammia Elder Law Firm in Winter Park, Florida, just outside of Orlando. And I've gotten a lot of questions recently about how has the world changed in the estate planning side of things in a post-COVID world? So before the 2020 and everything that we went through, estate planning has always been important. But after 2020 and everything we saw with the coronavirus and the world shutting down, and maybe you've had a loved one who got sick, maybe you got sick, and it makes you think, well, what happens if I become incapacitated? Do I have the right documents in place? Do I have the right people in place to be able to care for me if I'm unable to care for myself? So there's a bunch of documents that we can prepare in the estate planning side of things. Well, yes, there's the what happens if I die? Do I have a will? Do I have a trust? But also, what happens while you're alive if you become incapacitated? So do you have a durable financial power of attorney? The durable power of attorney says who can stand in your shoes for your finances while you're alive. So if ever you get sick and you can't pay your bills, is there someone who can do that for you legally, not just logging into your account and pretending to be you, but do you have someone who can help pay your bills, who can help make business decisions, who can help keep up the business side of your life if you can't do it for yourself? So the durable financial power of attorney is one of the most important documents you can have, and it's a document for while you're alive, who can handle your finances. Then we get to the healthcare side of things. So a designation of healthcare surrogate, or some people call it a healthcare power of attorney. Do you have something in place for your loved ones, your friends, family, whoever it is that you want to be able to make medical decisions on your behalf? We've joked in my family in the past that my dad didn't want my mom to make medical decisions. He wanted me and my brother because he was scared of how quickly my mom might make those decisions. So we've always joked, but he ended up in the long run making my mom his healthcare surrogate to make those medical decisions. But it's really up to you and your family situation who you trust to make those decisions on your behalf. It could be one person, it could be two people. It really comes down to the personalization of who is in your family, who do you trust, who do you want to act on your behalf. So there's the durable power of attorney, the healthcare surrogate. Then we have a HIPAA release. Every time you go to the doctor, there's some form or checklist for you to fill out, a HIPAA form, the Health Insurance Portability and Accountability Act. It's a federal law that says your health information is private. So we prepare a HIPAA release where you can designate who you want to be able to just talk to doctors, to just get an update on your condition, if ever you're in the hospital or sick or anything like that. So HIPAA release, you can list 5 family members, you can list one person. Again, totally up to your family situation and who you want to be able to discuss your health information with medical professionals. Then we have a living will. A living will is commonly known. It is a way of putting your wishes on paper. So if ever your healthcare surrogate has to make certain decisions, you're able to put on paper what happens if you are in a terminal condition, an end-stage condition, or a persistent vegetative state. Do you want artificial nutrition? Do you want artificial hydration? These are the things that you can put on your living will so that your healthcare surrogate takes some of the burden off of them to make these decisions for you. Now, I've kind of had 2 schools of thought. I've realized with clients over the years that for the living will, at least, there tends to be the side A, if ever this happens, I want this in writing. I want to take the pressure off of my family members. Please just let me go. Or there's the other side of things where maybe there's a little bit of a discomfort making this decision and putting this on paper because you really never know what's going to happen. And maybe you don't even want a living will and you want to leave it within the discretion of your healthcare surrogate. So kind of 2 schools of thought. Nothing is right, but it is good to have a living will just to put your wishes in paper so there's no issues in the future with anyone fighting or anything like that. So these are the important documents of what happens while you're alive if you become incapacitated. They're called Advanced Directives, or, what happens, the essential estate planning documents, what happens if you can't take care of yourself. So definitely recommend anyone over the age of 18. It's important to have these documents, because if the average 18-year-old who's been living at home and their parents are making all their decisions, now they're out in college, maybe still living at home, who knows these days. But an 18-year-old is able to make their own financial decisions, medical decisions. So anyone 18 and up, very important to have these advanced directives, and also especially later in life if you're a little bit more vulnerable to the times or to things that may come. So if you have any questions, please feel free to reach out. We're more than happy to help with any of your estate planning, Medicaid planning, veterans benefits, probate, guardianship, any of those needs. So stay tuned for more videos and we can touch on more topics. If you have any recommendations, please feel free to leave a comment.